Now, with the opposition expressing its lack of confidence in the Independent Electoral and Boundaries Commission to carry out the repeat presidential elections, pressure has been mounting to disband the electoral body. Now, according to Article 251 of the Constitution, the removal of the commissioners can happen for various reasons. Let's take a look at that right now. Now, a member of a commission can be removed from office for a serious violation of the Constitution or any other law, including contravention of Chapter 6 that deals with leadership and integrity. The other reasons for removal are gross misconduct, physical or mental incapacity to perform functions of office, or incompetence and bankruptcy. Now, an individual seeking to remove a commissioner is expected to present a petition to the National Assembly that sets out the alleged facts warranting their removal. The National Assembly will then consider the petition and, if ratified, send the petition to the President. Now, let's take a look at the President's options. The President, on receiving the petition, can suspend the member pending the outcome of the complaint, and also appoint a tribunal. That tribunal is composed of a chairperson who should be a judge of a superior court, as well as at least 2 individuals qualified to be high court judges and 1 other member qualified to assess the facts of the petition. Now, the tribunal is then tasked with investigating the matter, reporting on the facts, and making binding recommendations to the President. Now, within 30 days, the President is expected to act in accordance with the recommendations from the tribunal. So, in summary, the commissioners can only be removed from office if the individual or group seeking their removal is able to persuade the President through the National Assembly to establish a tribunal to investigate the commissioners' conduct. The investigations of the commissioners in question would focus on the individual's culpability of each commissioner, and the recommendations made to the President don't necessarily have to be about the removal of the commissioners from office. Now, on the other side of the political divide, calls for the removal of the Supreme Court justices have gained traction following the historic ruling yesterday. We also took a look at the procedures to remove a Supreme Court judge as laid out in Article 168 of the Constitution. Now, a judge of a superior court may be removed from office only on the grounds of their inability to perform the functions of the office arising from mental or physical incapacity, breach of a code of conduct prescribed for judges of the superior courts by an act of Parliament, bankruptcy, incompetence, or gross misconduct, or misbehavior. Now, the removal of a judge may be initiated only by the Judicial Service Commission acting on its own motion or on the petition of any person to the JSC. Now, the petition to the JSC should be in writing, laying out the alleged facts for the judge's removal. And once the JSC has considered the petition and is satisfied, it sends it to the President. What are the President's options? Let's take a look at that. Within 14 days, the President will suspend the judge and appoint a tribunal. Now, that tribunal will then inquire into the matter, report on the facts, and then make binding recommendations to the President. The President shall then act on those recommendations. It is also important to note, however, that a judge who is aggrieved by a decision of the tribunal may appeal against the decision to the Supreme Court within 10 days after the tribunal makes its recommendations. The President will then act on the recommendations if the final order of the Supreme Court affirms the tribunal's recommendations.